Regulation of the securities industry. Overview of the law.
The law in Malaysia. Constitution. Federal system of the government. Parliament can amend the constitution by 2/3 majority vote of both chambers. The constitution of 13 states comprising the federation provide a chamber, legislative assembly in each state. Federal laws made by parliament. State laws made by state assemblies. Both federal and state legislation are known as subordinate and delegated legislation. It is fully made up of rules and regulation enacted by an authority under powers conferred. Common law. Law ruled by British. English law was adopted indirectly because it was applied by the judiciary. In Peninsular Malaysia, the courts apply the common law of England and the rules of equity. Islamic law is only applicable to Muslims and administered in the Sharia courts.
In this topic also discuss about 1.2 legislative process. First of all, legislation refers to laws made by a person or body, which has the power to make laws in Malaysia. In addition, both Parliament and the legislative assemblies of each state possess authority to enact laws in their respective areas, and also laws made by Parliament may apply throughout the country or even extraterritoriality, but laws enacted by the state can apply only to that state. Other than that, a federal law is referred as an act, and a state law is called enactment except in Sarawak where it called ordinance. Next I will discuss about 1.3 the common law. As opposed to statute law enacted by legislature, is judge-made law or precedent. Next, a binding precedent is a judgment of a decision of a court of law cited as an authority for deciding a similar set of facts, a case, which serves as an authority for the legal principle embodied in its decision. Furthermore, a court is bound by decisions of a superior court where superior court had decided a case in the same area of law and on similar facts. Last but not least, 1.4 Securities Industry Law.
Based on topic, the legislation, which affects the security industry, is as follows by Securities Commission Act 1993, SCA, Capital Markets and Services Act 2007, CMSA, Securities Industry Central Depositories Act 1991, SIGDO, Companies Act 1965, CA.
Next, the SCA, CMSA, and SIGDA are collectively referred to as the securities law under Section 2 of the SCA.
Apart from the four acts, subsidiary legislation such as regulations, orders and guidelines issued by the SC supplement the regulatory requirements O.
Regulatory structure of the capital markets and services industry. First is supervisory and monitoring. Under the Supervisory and Monitoring is Companies Act 1965 and Securities Commission Act 1993, SCA. However, the Companies Commission of Malaysia, CCM, under the Companies Act. Meanwhile, the CMSA 2007 and SC is under the SCA 1993.
Besides, the regulatory structure of securities and futures industry encompass licensing. Securities under the licensing is Securities Commission Malaysia SC and Capital Market and Service Act 2007 CMSA.
Other than that, this topic also asks, why does the securities industry have specific law? Specific law are required to regulate the security industry, primarily due to the distinct nature of securities themselves, which are different from other types of properties or assets. A large part of securities regulation is directed at disclosure standard, ensuring that market are kept informed and ensuring fair trading on securities market. This because to make an informed investment decision, the investing public should be provided with accurate and current information to the corporation, and also because to ensure the accurate and timely flow of the information to the investing public. The three key objectives of securities regulation are: first is the protection of investor. This to protect investors from fraudulent, manipulate and misleading practices, and that ensure only fit and proper intermediaries provide investment services. Second is to ensure that market are fair, efficient, and transparent. This can provide for the requirement or regulation, among others, on the trading rules and approvals of exchange and intermediaries. The third key objective of securities regulation is the reduction of systemic risk. This to ensure that impact of financial failure of market intermediaries is reduced. Then, the function of regulation are: first, to define the key features of the capital market system and the role of the securities market institutions. Next, to steer market participants towards the adoption of best practices, and then to create disincentives against behavior that would be detrimental to the market.
Next I will discuss about the history and development of the securities industry in Malaysia.
First of all, the Malaysian securities industry effectively commenced on the 19th century with the emergence of British companies in 1930. After that, in 1960 the Malayan Stock Exchange was formed and public trading of shares began, and then in 1964 the Stock Exchange of Malaysia was established. In year 1968, the formation of the Capital Issues Committees, CIC, was followed. In 1973, the termination of current interchangeability between Malaysia and Singapore SEMS was separate into Kuala Lumpur Stock Exchange Berhad and the Stock Exchange of Singapore. Meanwhile, in the same year of July, a new company limited by guarantee, the Kuala Lumpur Stock Exchange, KLSE, took over the operation of the Kuala Lumpur Stock Exchange Berhad as the stock exchange. In 1983, the new Securities Industry Act came into effect on July 1983, replacing the 1973 Act. In 1986, the Kuala Lumpur Composite Index, KLCI, regarded as main market barometer, was launched.
In 1990, the Malaysian Central Depository SDNBHD was set up to implement and operate the Central Depository System, CDS.
In 1993, the Malaysian government, recognizing the importance of having a single regulatory body, established the SC by passing the Securities Commission Act 1993. And lastly, in 2004, start a new era for the Malaysian capital market. In addition, KLSE converted itself from a company limited by guarantee to public company limited by shares. Other than that, KLSE Berhad and its group of companies undertook a branding exercise on April 20, 2004 and converted its name to Bursa Malaysia. The approach to regulation of stock markets in Malaysia. The regulation of the financial markets has been undertaken in a more streamlined fashion in recent times following the establishment of the SC in 1993 under the SCA. Henceforth, there was one principal regulatory body to plan and to rationalize a broad developmental perspective and to formulate a practical, efficient and competitive regulatory system. Shift towards disclosure-based regulation. The securities industry regulatory framework in Malaysia has shifted from being merit-based to disclosure-based. The main objective of securities regulation is the protection of investors. This progression was considered necessary for the Malaysia capital market to become more efficient and credible market of international standing. Merit-based regulation. Merit-based regulation requires any issue or offer of new securities to be subjected to a review of their investment merit by regulators who may prohibit an offering of such securities. S15(1) of the SCA requires the SC to regulate all matters relating to securities and to take all reasonable measures to preserve the confidence of investors in the securities market. S212(4) of the CMSA mandates that all proposals. Disclosure-based regulation. Access to public securities markets for issuers is conditional upon providing full and accurate disclosure of relevant information in accordance with parameter established by the securities law and regulations. The framework disclosure-based regulation is the need for the issuers and intermediaries offering securities to provide investors with sufficient, accurate and timely disclosure of all relevant information regarding the company's business, prospects, to allow potential investors to make their own informed investment decision and to disclose any adverse situations or known risks connected with securities being issued/offered or the issuer itself. Capital Market Master Plan. First Capital Market Master Plan, CMP1 2001-2011. The CMP1 outlines 6 objectives as follow: to be the preferred fundraising center for Malaysian companies to promote an effective investment management industry and a more conducive environment for investors. To enhance the competitive position and efficiency of market institution to develop a strong and competitive environment for intermediation services to ensure a stronger and more facilitative regulatory regime. To establish Malaysia as an
international Islamic capital market center.
Capital Market Master Plan 2, CMP2 2011-2020.
Growth strategies prioritize key areas such as promoting capital formation, expanding intermediation efficiency and scope, deepening liquidity and risk intermediation, expanding growth boundaries through internationalization, and building capacity and strengthening information infrastructure. Governance strategies are aimed at fostering an enabling environment for expansion and innovation by enhancing product regulation to manage risk, expanding accountabilities as intermediation scope widens, strengthening the regulatory framework to make it more robust for a changing market landscape, ensuring an effective oversight of risk, strengthening corporate governance, and broadening participation in governance.
That all. Thank you.